Okay, y'all got to write up the papers from.
Yes, sir. We're going to have to change the offer because it can't be 6 years.
Well, the first one was 6 years.
Yes, but the second one can't be. It's only state jail felony.
Yeah, 6 years. That can't be.
So I don't know how.
It's going to have to be a state jail, so it can't be more than 2 years. So you're getting a benefit here. And they're going to have to redo the paperwork.
Judge, since it's not going to enhance anything later on because we've already got enough state jails, I'll just dismiss that one.
All right, we are looking at two cases here, 26 CR 852 and 853, the state of Texas versus Eric Lee Norman. And that's you, sir?
Yes, sir.
And you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive formal readings of the indictments and arraignments in each of these cases? Can we proceed? Stop.
Yes.
Okay. On 852, this is a state jail felony punished as though it were a third-degree felony?
Yes.
That's correct?
That's correct.
Okay. In summary, 26 CR 852 alleges that on or about January 7th, 2026, in Jefferson County, Texas, you committed a state jail felony of credit card or debit card abuse. Do you understand what you were charged with?
Yes, sir.
Paragraphs 2 and 3 go on to allege, though, that on January 12, 2018, in this criminal district court of Jefferson County, Texas, that you were convicted of the state jail felonies of theft and cause number 13-17219, as alleged in paragraph 2 of this indictment, and the state jail felony of burglary of a building in cause number 13-18271, as alleged in paragraph 3 in this indictment. Do you understand what you are charged with in paragraphs 1, 2, and 3 of this particular indictment?
Yes, sir.
And this constitutes a state jail felony, as alleged in paragraph 1. But this alleges paragraph 1 that on or about January 7th, you intentionally used a debit card knowing it was without the effective consent of the cardholder. That constitutes credit or debit card abuse, a state jail felony. But paragraphs 2 and 3 do constitute a state jail felony, but it's punished as though it were a third-degree felony because of the 2 prior convictions, as alleged in paragraph 2 and 3. Do you understand that, sir?
Yes, sir.
Which means you were facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in this case with you to be pleading guilty to 6 years imprisonment for the state jail felony, punished as though it were a third-degree felony. This sentence will run concurrently with the agreement in 26 CR 853, that state jail felony we will be going into here in a minute. Is that your understanding of the plan?
So here's the structure before things get complicated. 2 separate cases, both state jail felonies, but bumped up to third-degree punishment because of prior convictions. The deal on the table is 6 years, running together, not stacked on top of each other. Keep that number in mind. It's about to become the whole point of this hearing.
Ran concurrent with the other,
The other charges, the other state jail. That means they run together.
which other part? I'm already going 6 years.
I don't know what you're doing.
Yeah.
The 2 cases should be 6 years concurrent.
Concurrent with the other cases?
Yes. Yes, everything's on there.
Oh,
Is that your understanding of the plan?
yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
In each case.
Yes, sir.
Hold on, I'm trying to. We are getting a substitute for this device, right?
Yes, sir.
It wasn't made for a human to use. I don't know what they used as they go by, but you can't, the finger has to depress two devices and they're separated. Your finger isn't big enough to hit them both at the same time.
Yes.
As I'm explaining it.
Take your time.
Thanks for bearing with me.
Yes, sir.
Okay. If I follow these agreements, sir, you have no right of appeal in each of your cases. Do you understand?
Yes, sir.
All right, so let's get to the heart of the matter in each of these cases. In 26 CR 852, how do you plead to paragraph 1, alleging the state jail felony of credit or debit card abuse, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3, alleging those prior convictions on January 12th of 2018 that we went over, a state jail felony of theft and a state jail felony of burglary of a building out of this criminal district court of Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct with those voluntarily and because they are true as they are alleged?
Yes, sir.
And in 26 CR 853, how do you plead to paragraph 1, a state jail felony of theft of property, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges in 2016 in this criminal district court of Jefferson County, Texas, you were convicted of theft. And in 2018 in this criminal district court, you were twice convicted of theft cases on that date. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations in paragraph 2 voluntarily and because they are true as they are alleged?
Yes, sir.
And that constitutes a state jail felony. So you got a state jail felony punished as though it were a third degree felony in 852, and in 853, you have a theft case, which would have otherwise been a misdemeanor, but because you have 2 or more prior theft convictions in felony court, each time you steal a pack of gum, it's a felony offense from here on. Do you understand?
Yeah, yes, sir.
Best to be honest.
Yes, sir.
You don't have to worry about things. I'm going to show you in each case what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney?
Yes,
Are
sir.
the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each case
No objection.
without objection admitted. Among other things, the state you are mentally competent to enter your guilty pleas today. They are freely and voluntarily made. You know what you've been charged with, and in each case you are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1 was made a part of the record for all purposes. Help me out here. What am I missing on this? On 26 CR 853, the paperwork shows a third degree felony. How is it doing that?
Because of the 2 prior.
I feel, but the allegation 1 is theft of less than $2,500. That would be a misdemeanor, wouldn't it?
This is genuinely rare to catch on camera. The judge stops mid-hearing and questions the paperwork himself. Turns out the second case doesn't actually qualify for that third-degree enhancement the way the first one does, because the prior convictions used to boost it aren't the right type under the law. That's not a small clerical slip. That's the difference between 2 years and 6.
No, state jail.
Is it?
Well, so with the two priors and then after that, the prior. So there, I don't know what it is. Let me see. Jimmy said this.
Your Honor, I got 7 months already.
Hold on. Hold on. Yeah, this is,
Enhanced.
yeah, this is a
State jail, and you got 2 prior state jails.
This one doesn't have the two prior pages.
Hold on. I don't know what they are, actually, but they're.
Hold on.
These are state jails.
Yeah, but those are just thefts. You can't do that. You can't enhance it with thefts. Thefts. You can't do that sentence that he has. He should have alleged these burglary of them.
But it is a state jail felony, isn't it?
Well, there's 2 thefts.
It's just not a third degree felony.
It's not 3rd degree, it's a state jail.
Okay, y'all got to write up the papers for.
Yes, sir, we're gonna have to change the offer. Because it can't be 6 years.
Well, no, on, the first one was 6 years.
Yes, but the second one can't be, it's only a state jail felony.
Yeah, 6 years, that can't be.
So I don't know how.
It's going to have to be a state jail, so it can't be more than 2 years. So you're getting a benefit here. And they're going to have to redo the paperwork.
Judge, since it's not going to enhance anything later on because we've already got enough state jails, I'll just dismiss that one.
And this is how it gets fixed, not by forcing a sentence that doesn't legally hold up, but by the prosecution just dismissing that second case outright since it wouldn't have added anything anyway. The first case, the 6-year sentence, still goes forward exactly as agreed. It's a good look at everyone in the room, judge, prosecutor, defense, actually working the problem out together instead of just pushing through.
The state jail.
Oh, okay. So 26,853, you're just going to dismiss.
Yeah, it's not going to enhance anything later on. It's not going to help anything, hurt anything.
Okay,
I'll take
hold
care.
on. Hold on.
Yes, sir.
We got a victim here. Whatever's going to happen, this victim is not standing out in the cold with a loss of something that the defendant would have been otherwise responsible for, correct? We got a victim here.
In the offense report, they did say there was a $115 loss, but they have not sent anything back to our office requesting us to collect their restitution for them. So,
Okay, so then you're going to send me a dismissal on
Yes, sir.
853.
yes, sir.
On 26 CR 852, that's what we're standing by. That one will go forward. You have pleaded guilty. And to paragraph 1, voluntarily, knowingly, intelligently. And to paragraphs 2 and 3, you have pleaded true to those 2 prior state jail convictions. This is, and there's enough from State's Exhibit 1 to find you guilty beyond a reasonable doubt. This constitutes a state jail felony, punished as though it were a 3rd degree felony. I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. We are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 6 years on that case. So you understand what has happened today, sir?
Yes, sir.
All right, anything else?
No, sir.
That is all.
Thank you, Judge. Thank you.
Then the 8 wasn't.
With me visiting with her and preparing for this trial,
Yes.
and I did communicate with Mr. Ham, she was hearing voices, and the voices wasn't me. So out of abundance of caution, I filed a motion to have her listed for competency because and this was last week when I was talking to her. The voices started coming to her, and like I said, it wasn't me talking to her. So I got kind of nervous about that. So I wanted to.
Did you hear their voices?
No, I didn't hear them.
Okay.
And to my understanding,
Had to be asked.
well, hey, and to my understanding, she does have a history of mental illness.
Well, you need to look into that and
Yes.
get
that. But yeah,
something firm so we can make a ruling on it and whether
Yes,
it's
sir.
competent or not.
but I did file requesting to have Dr. Rapone at least look at it.
Yeah, I'm printing it out. Just a second.
Are you retained on this one?
Well, sir, next one.
I see she's got some prior convictions of aggravated assault and delivery of a controlled substance. Is that?
Yes, sir. And I also understand from talking with Mr. Ham, and another reason I want to reset it as well, in addition to getting her tested is that I understand that there's another case that's supposed to be coming that's going to be indicted, I guess, soon. I don't know the details of all of that. Mr. Ham, I'll tell you about that. But
They were filed.
I do understand there's another case that's coming down the pipe.
4 wasn't enough.
No, we wanted more. There's one more coming to.
Let's see.
It's actually scheduled to go before the grand jury this week.
We got 4 felonies, separate felonies within a span of 3 months.
Yes, sir.
That timeline is really what's driving this whole hearing. It's not one bad night. It's 4 separate serious cases stacking up in just a few months, plus another one reportedly headed to the grand jury this week. That pattern is exactly the kind of thing that makes a court want a real competency evaluation before moving forward.
And I think that
Where is she now? In Cutting? Okay.
And just formally, Judge, the state is ready to move forward on the aggravated assault with a deadly weapon, clause number 25 DCCR 0885.
Okay. Hey, Langston, your motions for an examination regarding insanity, we need to put something on the record other than just a summary. The issue has been raised. What is it about it that you can articulate that we can put into the record?
yes, I can.
Because this is just, a summary, and everybody would file motions if
Yes, sir.
it was just this succinct. Because what's a problem here, among other things, is we've got this cocaine charge that comes along.
The judge isn't dismissing the competency concern. He's just saying a one-line motion isn't enough to act on. He wants the actual basis spelled out on the record, not just a summary, before ordering an evaluation. It's a good example of the paperwork needing to match the seriousness of what's being asked for.
After all of these, you have 4 separate events here on separate dates in just a matter of months: an aggravated assault with a deadly weapon, and 885 with 2 prior second-degree felony convictions. So that second-degree felony, the first-degree felony punishment, then 25-10, evading arrest or detention, third-degree felony with the 2 priors alleged. So that becomes a second-degree punishment. Then illegal possession of controlled substances, state jail felony with those 2 priors in sequence. So that becomes state jail felony punished as a second degree. Call up your peeps. And what did I miss? Collision, third degree punished as a second. So, and what bothers me is this was just 4 different serious felonies within just a span of about 4 months. Anyway, if you can articulate and get this to me, and then we'll
Just,
we'll work on that. Getting Dr. on, and then, but we're going to foresee and set it in 2 months. Okay,
No.
A trial in 2 months.
okay.
Is that going to be good for everybody here?
Yes, sir.
Thanks. So here's the motion. Thank you. All right.